This module is about the Erie Doctrine. Ooh, that sends shivers through everybody because most people agree that this is the toughest doctrine in all of civil procedure. But you know what? Let's focus on this because we're going to cut this down to size. And let's start right off by realizing when the problem comes up because it's fairly narrow. An Erie problem comes up only if we are in federal court, and almost always when we're in federal court under diversity of citizenship jurisdiction. This is not a problem that we are often going to encounter in federal question. So we're in federal court under diversity jurisdiction. Okay. Now, there is a particular issue that the federal judge must decide. And the Erie question is this. In deciding that issue, must the federal judge apply state law, or is she free to ignore state law? That's what Erie is all about. There is an issue that she must decide. What is the statute of limitations, or who pleads on this issue or that issue? An issue that federal district judge must decide in a diversity case. And the question for us is that in deciding that issue, must she apply state law, or is she free to ignore that? The black letter rule is very easy to state. In fact, deceptively easy. The black letter rule comes from the Erie case itself, 1938 famous case, Erie Railroad versus Tompkins. And the black letter deceptively easy rule is this, that in diversity cases, a federal court must apply state substantive law. So if this issue that the federal district judge has to decide is an issue of substantive law, then she must apply state law on that issue. Now, why would that be true? Well, Erie told us that that's true for two reasons. That answer is compelled by the Rules of Decision Act. The Rules of Decision Act is Section 1652 of the Judicial Code, and it's also compelled by the Constitution, specifically the 10th Amendment. The 10th Amendment basically says that powers that are not given to the federal government in the Constitution are retained by the states. And the Rules of Decision Act echoes that by saying that in these cases, the federal court must apply state law, and as it's interpreted, on substantive matters. So we're in a diversity case. Federal judge has an issue to decide. If that issue is substantive, then Erie says she must use state law. Now, that is what Erie talks about. But it turns out that the starting point under the Erie Doctrine is not Erie at all. It's a totally different case. It's a case called Hanna versus Plumer. Hanna versus Plumer from 1965. Now, here's what's amazing about Hanna. It showed us that what we thought was one doctrine, the Erie Doctrine, is really two doctrines. There's a Hanna doctrine and there's an Erie doctrine. Or, as some people say, there's a Hanna prong to the analysis and there's an Erie prong to the analysis. So with that background, let's tackle this area in three sections. Section A will be the Hanna prong of the analysis. Section B will be the Erie prong of the analysis. And Section C will be a couple of hypos. They're going to be hypotheticals to test how we have gleaned the Hanna and the Erie prong of analysis. Section A, the Hanna prong of analysis, tells us this, that the very, very first question we ask is this: is there a federal provision on point that directly conflicts with state law? Is there a federal provision on point that directly conflicts with state law? So remember our scenario. We have a district judge. She has an issue to decide. Now, on that issue, is there a federal provision on point on that issue that directly conflicts with state law? If the answer to that question is yes, then life is easy. If the answer is yes, then we apply the federal law. We apply the federal law as long as it is valid. We apply the federal law as long as it is valid. And the court in Hannah said this is not an Erie issue. This is an issue that is decided under the supremacy clause of the Constitution. If there is some federal provision, a federal directive on point that rules for this issue, and it directly conflicts with state law, it wins as long as it is a valid federal provision. Now, that federal provision might be in the Constitution. Those are automatically valid. It might be a federal statute. And you know about validity of federal statutes in studying constitutional law. That's not something we do here. But it might be that that federal provision that's on point is a federal rule of civil procedure. How do we determine whether a federal rule of civil procedure is valid? Well, we have to look at the Rules Enabling Act. The Rules Enabling Act is Section 2072 from the Judicial Code. And it says that federal rules are valid if they do not modify substantive rights. And the way this has been interpreted by the Supreme Court has been very, very passive. Generally, there are a whole lot of justices who say that a federal rule of civil procedure is valid under the Rules Enabling Act if it is just arguably procedural. And they're all arguably procedural. Why? Because they're all in a pamphlet that says rules of procedure. And in fact, the Supreme Court has never held one invalid under the Rules Enabling Act. So if the federal directive, the federal rule of civil procedure is on point, then it trumps as long as it's valid, and an FRCP is valid if it's arguably procedural. Now, you may have read a case called Shady Grove from 2010, and in Shady Grove, Justice Stevens argued that there should be a stricter test for validity under the Rules Enabling Act. But as I say, the bottom line is the Supreme Court has never held one invalid under that Rules Enabling Act. So this is the Hannah prong of the analysis. And it's exactly what governed in Hannah versus Plumer. In Hannah, you had a case in federal court in Massachusetts, and the defendant was served through substituted service of process. That's okay under Rule 4. But under Massachusetts law, it was not okay. This kind of case, you could not have substituted service. So it's a diversity case in federal court. What does the federal judge do on how you can serve process? Well, the first thing we know is you got to ask yourself, is there a federal rule, a federal directive, a federal provision of any kind on point that directly conflicts with state law? The answer was yes. Federal Rule 4 was on point, and it conflicted with the state law. And then we simply say, well, if there is a federal provision on point, Rule 4 was, it wins. It trumps state law as long as the federal provision's valid. And the FRCP was valid because it's arguably procedural, did not modify substantive rights or anything of that sort. So the first thing we do is not knee-jerk about substance and that sort of stuff. What you do is ask, is there a federal directive on point? That's what you do. That's the Hannah prong. That's always first. Now, Section B is the Erie prong of the analysis. This comes up if there is no federal provision on point. Now, there's no federal provision on point. We have a true Erie question, and that means this. The federal judge must apply state law on matters of substance, substantive issues. But we do not have to follow state law if it is not a substantive issue. Now, how do we know if something is substantive for this purpose? The Supreme Court has been very, very unclear here through the years. Very, very unclear. And let me caution you as we go through this. I'm going to give you a theory, but this is an area where law professors are famous for having their own theories. So if your professor has a theory of Erie, you got to know that theory of Erie. But I think any theory of Erie must make sense of three famous phrases from three famous cases that the Supreme Court has decided in the Erie prong of the analysis. And again, what's the Erie prong? This is where there is no federal provision on point. And so the federal judge has to decide something. There's no federal provision on it. So if it's substantive, she must apply state law. If it's not, she can ignore state law. Now, what are the three famous phrases? And the court has never told us how these three phrases interrelate, how we're supposed to apply them together. The court's never told us that. That's why this is so confusing. My own advice is, unless your professor has a different theory of Erie, I would say, let's apply all three of these tests and then just come to a reasonable conclusion. This is an area kind of like personal jurisdiction, where there is no single right answer in many, many cases. The first phrase that we ought to deal with is outcome determinative. And that comes from the 1945 case of Guarantee Trust versus York. Now, here are the facts. Under state law, the case that the plaintiff filed would be barred under the statute of limitations. He waited too long before he sued. And so under state law, that case should be dismissed right now because of the statute of limitations. The case is brought in federal court under diversity jurisdiction, and the federal judge wants to ignore the state law. Notice, this is an Erie problem, not a Hanna problem. Why? Because there's no federal directive on point. There's no federal statute of limitations here. And so it's a pure Erie question. And the court holds that the federal judge must apply state law on statute of limitations. In other words, we can say that statute of limitations is substantive for Erie purposes, and that's true to this day. So in a diversity case, we must apply state statute of limitations because it's substantive. Why is it substantive? Well, the court in Guarantee Trust versus York said that it's substantive because it's outcome determinative. Now, what does that mean? Here's how you apply that test. If we use the state law, this case is dismissed right now because it's barred by the statute of limitations. If we ignore the state law, this case is not dismissed and it will proceed in the litigation stream. That, said the court, is a different result. And we should not have different results in federal and state court, at least not insofar as the legal rules will determine that. And so if we applied state law, the case is over right now. If you ignore state law, it goes forward. Those are different results. We don't like that. It's outcome determinative. Therefore, you must follow state law. Now, that was fine on statute of limitations. The problem is that at some point, everything becomes outcome determinative. I mean, if you had a state rule that said that pleadings must be filed on polka dot paper, and then in federal court you don't file on polka dot paper, Is that outcome determinative? Well, you could say, well, yeah, if you tried plain paper in state court, you'd be dismissed. You couldn't even file. But that's ridiculous. So the outcome determination test, nobody's ever been wild about it, but the court has never expressly overturned it. Second famous phrase, second famous case, balance of interests. The case is Byrd versus Blue Ridge. Byrd versus Blue Ridge. A particular issue under state law was to be decided by the judge, no jury, no jury. The judge had to decide this issue, not the jury. You have a diversity case under this law. Does the federal judge have to follow state law on this? Again, it's an Erie problem, not a Hanna problem, because there's no FRCP or other federal provision on point. And so the court has to look at whether this allocation of authority between judge and jury, is that a matter of substantive law? If so, you got to do what the state did. The outcome determination test does not help you here, because maybe the judge and the jury would have come to the same conclusion. So it doesn't really help us here. And that's why the court came up with something new. The court says that if a provision, a rule, a law is not clearly substantive, the federal court should apply it. The federal court should follow state law, even though it's not clearly substantive, unless the federal court system has some interest in doing it differently. So we know if it's substantive, the federal judge must follow it in a diversity case. Here we're saying even if it's not clearly substantive, you should follow state law unless there's some federal interest in doing it differently. And here there was a federal interest in doing it differently. This was a matter of allocating authority between judge and jury. That is a housekeeping matter on which the federal courts ought to be free to do their own thing. They should not be stuck by what the state law is. And what the court did here was balance the interests. The state, even though it said the judge should decide this issue, not the jury, the state had no reason for its rule. It said, well, this is just always the way we've done it. We don't know why. But the feds had a very strong interest in doing it differently because of the Seventh Amendment. We like the jury system, especially in federal court. And so the idea of the jury system embodied in the Seventh Amendment, even though not exactly on point here, is one that outweighed the state interest. There was no interest on the state side. There was a rule, but it didn't know why it had the rule. We like to have juries decide fact questions, so the federal interest outweighed the state. Now, that was great on the facts of that case. But the problem with Byrd is the court's never really gone back to it. It's never really applied it much beyond that. Nonetheless, it's not overturned. The third famous phrase and famous case in this area, the twin aims of Erie. And the twin aims of Erie come from Hanna versus Plumer. Twin aims. So obviously there are two. What are they? The twin aims are, number one, avoid forum shopping. Avoid forum shopping. And number two, avoid the inequitable administration of law. Avoid the inequitable administration of law. Those are the twin aims. Now, how do you apply the twin aims test? It's pretty easy. Here's what we do. At the outset of the case, right, when that case is being filed, we ask this. If the federal judge ignores this state law, will it cause parties to flock to federal court? If the federal judge ignores this state law, will it cause parties to flock to the federal court, to forum shop in favor of the federal court? If so, that's a bad thing. We don't like that. We do not want to facilitate forum shopping. in part because it's unfair. It's automatically unfair to in-state citizens because in-state citizens cannot invoke diversity jurisdiction and therefore cannot get to federal court to avoid that state law. So we have three tests. We have outcome determinative, we have balancing the interests, and we have the twin aims of Erie, and the court has never, ever told us how we mesh those. It had a golden opportunity in 1996 in a case called Gasparini, but most people think the court failed very badly to give us a very good approach to how to do Erie. So I think the best we can do on the Erie side of things is to account for those three tests and come to a reasonable conclusion. Now, let's go to Section C and do some hypos. We've seen the Hanna prong of the analysis. We've seen the Erie prong of the analysis. Now it's hypo time. Hypo number one, and we're only going to do two, but hypo number one. We have a case that's filed in federal court under diversity jurisdiction, and it is filed as a class action. Plaintiff files a class action in federal court under diversity jurisdiction. Federal Rule 23 would allow this to go forward as a class action. We meet all the requirements for Rule 23. It would be a class action under Federal Rule 23. But state law says that in this kind of claim, the plaintiffs cannot proceed in a class action. They must sue individually. State law says in this kind of claim, no class actions. You gotta go individually. Now, you're the federal judge. It's a diversity case. You have an issue to decide. Can this case go forward as a class action? What do? First, do not knee-jerk and jump to outcome determinative substance. Don't do that. Apply the Hanna prong. Always, you do that first. Is there a federal provision on point that directly clashes with state law? Yes. Federal Rule 23 is on point. It governs when we can go forward as a class action. It clashes with state law because state law said, no, you cannot do a class action here. So you have a federal directive, a federal provision on point. What do? You apply the federal directive as long as it's valid. Is Federal Rule 23 valid? Well, under the Rules Enabling Act, is it arguably procedural? Certainly, it's arguably procedural. It's about how we aggregate claims. And indeed, the Supreme Court upheld the validity of Rule 23 in Shady Grove. That fact pattern is Shady Grove. And so, yes, the federal directive's on point. It wins. This is not an Erie problem at all. It's a Hanna problem. If there's a federal directive on point, it wins as long as it's valid. And again, 5 justices in Shady Grove said it was valid. 4 because it's arguably procedural. That's all it took. And that's hard not to meet. And Justice Stevens had a little bit stricter test. But again, as I say, the Supreme Court has never held one of those FRCPs invalid. Now, hypo number 2. This is great. Let's say we're in State X. And the legislature in State X is worried about healthcare costs. It wants to reduce healthcare costs. And so it decides that it's going to have a special rule about medical malpractice litigation. And State X passes a statute that becomes effective, and it says that when the plaintiff sues for medical malpractice, before she can go to trial, she must go to arbitration before a panel of doctors and lawyers and judges. Now, plaintiffs hate this. They would much rather go to trial in front of a jury because jurors cry when you tell your story. Judges, lawyers, and doctors don't cry so much. So plaintiffs do not like going to arbitration before these professional folks because they just figure they're not going to win as much money. The statute says that your medical malpractice case, you file it, that's great. You will be sent to arbitration before one of these panels. And after the arbitration, if you do not like the result, you can come back into the litigation stream and go to trial. But the jury will be told about the arbitration result. So you file a medical malpractice case, you got to go through arbitration. Arbitration says you win $5. You still think it's $1 million case. Now you go to trial. And the jury will be told, however, that arbitration said $5. Still, you might win your $1 million. But the idea, obviously, is to reduce the amount of medical malpractice litigation. Now, you know what happens. A citizen of another state, we were in state X there, so a citizen of state Y comes into state X on vacation, gets hurt, gets sick, goes to the doctor, claims that the state X doctor committed malpractice. The citizen of state Y sues the doctor, citizen of state X. It's a diversity case for medical malpractice. We're in federal court. You're the federal judge. Must you apply that state arbitration rule? Must you send them to arbitration, or can you ignore that rule? How do you analyze it? First, Hannah, is there a federal provision on point? No. There is nothing anywhere in the federal rules or statutes about medical malpractice arbitration. So, second, it is a pure Erie question. And I think the best we can do is just apply those 3 tests and then come to a reasonable conclusion. First, is this outcome determinative? Well, I don't think that's clear. I mean, maybe the arbitration panel and the jury would come out the same. Who knows? We have a sense that the arbitration panel will give you less money, but we don't know that. So it's not clear what outcome determination would mean here, if that's met at all. Let's go to the second. What about balance the interest? Oh, well, think about this. This is a lot different from Byrd versus Blue Ridge, because here the state has a big interest. In Byrd versus Blue Ridge, the state had no interest because it had no reason for its rule. Here, the state has a strong reason for its rule. We're trying to reduce healthcare costs. And so the state interest weighs a lot in this case. Is there any federal interest here? Well, there's always a federal interest in having juries decide stuff, but here, we're not doing away with the jury. All state law does is delay the jury. It doesn't do away with the jury, as state law did in Byrd. So this is a different case from Byrd, and it arguably weighs in favor of state law. State has a strong interest. Federal interest in juries is not being abrogated. It's just being delayed. Then what about the twin aims? The twin aims. If the federal judge ignores this state arbitration law, will it cause parties to flock to federal court? Absolutely yes. Every plaintiff who can get into federal court will go there because she will not have to put up with that silly arbitration panel. And that promotes forum shopping, which is a bad thing, they say. And it is also going to result in the inequitable administration of the law. Why? Because state X plaintiffs cannot get away from the arbitration provision. Because a state X plaintiff suing a state X doctor cannot go to federal court under diversity. So that's unfair. Only citizens of other states can go to federal court and try to get this different approach. So because of the twin aims, the federal judge would likely say, I'm going to apply the state arbitration panel. Because if I don't, it promotes forum shopping and therefore is unfair to the citizens of state X who cannot avoid state court. They cannot come to federal court. Come to a reasonable conclusion. That's all we can be expected to do in that Erie prong of the analysis. Folks, thank you, and I hope Erie is less scary than it was about a half an hour ago.